Thank you. Can I welcome the Master to the committee and appreciate your opening remarks. And maybe to just pick up on your last point, surely judges should know what the law is themselves. Why is it up to members of the Oireachtas to tell judges what the law is, whether it's domestic law or EU law? Do you believe that there's an issue here, and are those that advocate on behalf of borrowers not outlining this to judges before the courts, or is there a view that judges are dismissing this issue?
This is astonishing ignorance on the part of the public as to what exactly judges know or don't know. Technically, they come into court with a clean sheet of paper. And it's the responsibility of counsel and the parties to tell the judge what the law is. Now, often it's the case that the judge will say, you don't need to tell me, I know what the law is. But sometimes it's the case that a position or a proposition or a submission is made by one party to which the other party is not in a position to respond. The judge then is left with the situation that he may or may not have the resources to go and inform himself, but there's no obligation on him to inform himself. When I started as master, we had a rather amusing practice in place, which was the link between this place and that place, which was that I was sent 3 copies of every statutory instrument, three hard copies in a brown envelope. This was the link between the Oireachtas and the Judiciary. Apart from that, there is no formal method of communicating the content of statutory instruments. And so the problem is, I quote here from a book on the law of the European Union by Trevor Redmond. He says, Article 4 of the TEU imposes on the member states an obligation to take any appropriate measure, general or particular, to ensure fulfilment of the obligations arising out of the treaties or resulting from acts of the Union institution. This obligation provides the bedrock for another principle that is similar to but distinct from the principle of effectiveness and runs parallel to it. It is the principle of effective judicial protection. If the judges do not know the law, they cannot effectively judicially protect the interests of the citizens of the community. And there is an information deficit in how the judges are operating at the moment. I'm not sure what the solution to this is, but it does seem to me that we may be focusing in or narrowing in on the solution in relation to credit servicers and purchasers with this directive, because it seems to me that an obligation arises now on the central bank to keep the public informed as to what the position is in relation to forbearance, rates of interest and so forth. And that obligation is one which they cannot continue to shield behind, if you like, a big black hole of confidentiality. The public is entitled to know what is going on in relation to forbearance of debt and mortgage arrears. And the public cannot be shielded from, the public cannot have judicial protection without knowing what the central bank is doing.
Okay, so obviously we have a multitude of cases, and some of those cases are very different, complex, and some of them are very similar. And therefore, you make the point that an onus on the central bank to inform the public in relation to their rights and the obligations under directive and other types of EU and domestic legislation. And you rightly point out that judges rely on counsel on both sides to inform the judge as to the legal position in relation to the case that is before him or her. And the judge may draw from his or her own experience in relation to interrogating the counsel. But again, going back to your statement about the Oireachtas informing judges, it is the council's obligation to inform judges in terms of the legal position that is before them. Is it your view that there is a misleading of judges in relation to cases that are before the courts from counsel or advocates in certain circumstances?
Can I put it this way? There is information there, it's out in the ether. It's the law. But for a lay litigant, there's a paywall. He can't access this information without committing himself to huge expenditure. That being the case, there is certainly the temptation on counsel to dodge the awkward questions in relation to the legal position. He's on a fair bet that he won't be picked up on it by the lay litigant on the other side. I'll give you an example. The 2013 Act, which you passed here, it allowed for the Circuit Court to adjourn a repossession case, what they call a repossession case, for 2 months to allow the defendant to consult a PIP, a personal insolvency practitioner. Now, the language of the Act was fairly clear. It said that the judge may do this. Of course, they can't say the judge shall do this because that's an interference with the independence of the judiciary. But there you've got a provision which says that the judge may do this, and it's really a may off his own bat. So that was 2013. I have never yet seen a case where a lay litigant was told that he was given 2 months to go and consult a PIP. And the reason for that is because the counsel on the other side didn't remind the judge that there was an option there for him to adjourn for 2 months. Now, judges are tearing their hair out and finding reasons to adjourn, but there is a specific statutory reason which wasn't drawn to the attention of the judges in any way by plaintiffs in these cases. That's the 2013 Act. I'll give you another example, which I think is quite interesting, and that is the introduction of the CCMA, the Code for Mortgage Arrears, which came in 2013. I don't know whether you've read the submission from Professor Kenna. In any event, the Code Conduct on Mortgage Arrears, the MARP process, was introduced in 2013, late 2013, a code. And I recall some surprise when in court I produced copies of the code and handed it out to the parties in court and said no one was going to get an order for possession until they had complied with the code. Now, nobody had told me to do that, and nobody had told the judges that there was a new code. And in fact, we then had a ding-dong battle with a judge saying eventually that the code wasn't justiciable, that's to say it wasn't legally binding in any way. And eventually it went to the Supreme Court, and another judge, who was later the Chief Justice, decided that only one part of the code was legally binding. That was, I can't remember which one it was, but the point is, it was an argument about, it was a developing understanding of the nature of the legal obligation arising out of it. And then finally, in 2020...
The Dunn case in terms of the moratorium, was it? That part was... That's right. That's the one that was held to be... 2015,
in 2020, I should say, in 2014, that's a year after, the European Commission, the European Union, adopted the first mortgage credit directive. That's 2014. And by 2020, the Supreme Court, the penny had dropped with the Supreme Court. They said, actually, if you look at the 2014 directive, these codes are enforceable. I mean, this is ridiculous. It took 7 years for the courts to realise that these codes are enforceable. During that time, how many people lost their homes? I don't know. But 7 years, there's something wrong with the system which allows a court to proceed on the basis of a misunderstanding. You have to go back to the EU and say, I wonder can the EU fault Ireland for not providing the mechanisms for judicial protection. I'll give you an example of that. Sorry, this is well worth my reading this out, I think. This is from the same book. He says, on state liability, he says, the principle of state liability applies in any case in which a member state breaches EU law. Whatever be the organ of the state whose act or omission was responsible for the breach, even the legislature. So there's the courts could be responsible for the breach, the central bank could be responsible for the breach, the barristers, but they're not an organ of the state, the legislature, which has failed to communicate the material to the courts. I'm just taking a look at the directive we're dealing with here. This is it here, and it's quite a long, lengthy document, and it has something like 60 preambles, 61 preambles, which are actually part of the law. They have to be read by the judge who's considering the meaning of the words, the meaning of the terms thereof. And the Oireachtas didn't get this yet, as far as I know. Can't be certain of this now, but listening to Senator Mark Daly the other day at the Shannon Committee, he appears to be of the view that they don't get these directives until the statutory instrument is produced. So the Oireachtas never had a chance to look at this directive and say, gosh, this is interesting. There are bits and pieces out of that we should be looking at as plenary legislation. So a decision to go the plenary route as opposed to the statutory instrument route should be made before the paperwork is inked by the department which is preparing the statutory instrument. But the one we're interested in today, the part of this directive we're interested in, this is the subject of today's, is way at the back of it. Sure, nobody looks that far. Not even if the TDs got this, they wouldn't have gone this far. It's Article 28. Sure, you've given up on that. You answer the phone and you're gone to another committee meeting. And there it is in Article 28. And if the Dáil had looked at this beforehand, and if they'd taken advice on it, they would have said, well, hang on, Article 28 is amendments to Directive 2014, which we've already transposed. And they'd have said, this is quite important because it includes different language for forbearance. It includes a reference to partial debt forgiveness. This is a significant change in law. That article in itself, which was the only article amending the earlier directive, could have been lifted straight out and transposed instantly. Well, not instantly, obviously, it would take a few weeks. But it didn't have to wait the 2 years while the rest of the directive gathered dust.
Can I ask your views in relation to whether the directive should be transposed through primary legislation or not, and if so, what are the reasons for it?
There's an example of that. I can give you an example. The last directive we were looking at there, that's 2014.
Yeah.
See if I can find it here. I have it here somewhere. There was a provision in it. Yeah, that's there. There was a provision in it which said that that's not it. That's a pity I can't find it now. Offhand, it's here. Too much paper, that's the problem. There was a provision which said that there should be measures put in place to ensure that the best price be obtained for the mortgage property, the security property, when it's being sold.
Yeah.
So as if there's a balance due to the debtor, or it could be a balance due to the debtor, or if there's a residue due, that also has to be determined.
Article 28.5.
28.5, yeah. So, it said measures should be put in place. Now, what measures did they put in place for that? That's a hard law provision. Put measures in place. You can't have a measure which can be ignored or dressed up or forgotten about, brushed under the carpet. A measure which is not complied with should be sanctioned. It was actually transposed, and this is the phraseology used. Article 20. This is now the regulations which transposed the 2014 directive, and at 29 it said, where the price obtained for the secured immovable property affects the amount owed by the consumer under the credit agreement, the creditor shall ensure as far as reasonably practicable that the secured immovable property is sold at the best price reasonably obtainable. And that's a soft law provision, which is not a transposition of what's required under the directive. The directive required measures to be taken. So structure.
The directive, because I have that article in front of me. The directive stated that member states shall have procedures or measures, as you say, to enable the best efforts price for the foreclosed immovable property to be obtained.
Yes.
And so you argue that the transposition of that is a lot softer.
Yes.
Because it's where practical and. Yes. It's just about the price, as opposed to there's no measures, there's no
structure.
Isn't that, and we've heard it before, Chairperson, this committee where receivers have been appointed, where properties have been sold at very reduced values, indeed with large fees in terms of being charged also by receivers, and best price has been argued has not been obtained. What's your own view in relation to that?
The provisions in the our regulations under the 2014 directive, which say the central bank should supervise this or regulate this, these are wholly inadequate, because there's no question of the central bank interrogating each and every sale and publishing their results. For instance, you might find that a particular receiver would have a particularly bad record, or that there might be a pattern in the sales that were being achieved by a particular receiver or a particular bank. And these are concerns of the possibility that there may well be profiteering taking place, gouging of the borrower and profiteering by the investor. So, in my view, looking at the new directive and the new provisions for forbearance, we're facing into the same situation where any investigation by the central bank on forbearance is not going to produce publicly published material. And the decision to employ the central bank is one that we've taken. It's not one that the EU imposed on us. The EU says these are the forbearance measures that should be adopted. We could have said, right, this is a whole new ball game. Forget about the central bank. We'll now structure a mechanism for resolution of debt in accordance with the provisions of the directive. And that would have required primary legislation. And the point about it is that it would be transparent procedures. Everybody would know what was happening, and in that way, the effect utile, as they call it in Brussels, the effective application of EU law is secured. I'm concerned about going too far about suggesting that there's any sort of pattern of underselling, but there's no doubt about it that an individual who's concerned about this doesn't appear to me at this point in time to have any access to justice.
But is there, in your, like, the directive calls for measures or procedures to be put in place to get best price. So is there, from your understanding and from the position and the unique position that you have as Master of the High Court, from the cases that you've seen, has there been procedures or measures in any of these cases outside of what anybody would do, which is put it on the open market?
Yes. So there have been, yes. Sales have occurred which are not on the open market. That's why I mentioned market covert in the opening statement. And it's concerning because it's quite simple. It's simple for an auctioneer to say, well, I didn't get any response to my queries around the usual gang was asked were they interested in this piece of farmland or whatever, so I sold it off to somebody else.
But doesn't the directive not ensure that decision is not made up to the auctioneer or the receiver? It says member states shall have procedures or measures.
Yes, it does. And a soft law directive, a soft law set of regulations isn't going to secure that because it's inaccessible to accountability.
Okay.
I put forward some questions in the opening statement, and I've added to them. I now have 20 questions, and I'm just wondering to myself how would I best use my time here. And I thought that the best way of doing it was, if you like, for me to assist the committee in interrogating the central bank. If the central bank is the body which is going to have to oversee or overview this material, and I don't actually believe the central bank wants to overview it, but if it is, then they need to start thinking seriously about what yardsticks they're going to apply.
We've received those questions, and it'll be a matter for the committee, but I assume we'll ask the central bank to answer each and every one of those questions individually for the committee's benefit as we're scrutinising and reviewing this issue in terms of the Credit Servicers Directive. Can I ask you what benefit from borrowers arise from this directive and its legislation?
Borrowers in arrears obviously are in trouble, and they are now entitled to be offered forbearance terms which are reasonable, And you might say they were entitled to that in the first place under the 2019 Act. I remember the 2019 Act. You may, possibly don't remember it. It went by in a flash and nobody paid any attention to it. But the Professor Kenna mentions it in his submission. He says that this set forward a template for assessing how the circuit court judge should deal with a possession case or a repossession case. And it basically said, first of all, he should, in cases where the PIP transaction had failed, he should then consider proportionality in relation to the situation that had arisen and that presented itself in court. The Act also mentioned alternative bodies which might be designated by the Minister as providing a similar mechanism to the PIP, but not on an insolvency basis. So the great benefit of this directive is that it's not at the courtroom stage that the forbearance engagement takes place. It's supposed to take place before proceedings commence. This is why I called it the new moratorium. It's something that once proceedings commence, they really should be injuncted. They should be stopped if the reasonable efforts have not been made. So here we have a situation where a lender will say, oh, well, I did make a reasonable offer and I'm communicating that to the central bank, and the central bank says, yes, that's okay, now you can issue the proceedings. Now you have to go back to court and apply for an injunction to say, no, the offer that was made was not reasonable and the process undertaken was not in accordance with what the EU expects us to do, not what the central bank expects us to do, which is very little. So the hard law kicks in before the proceedings commence. Now that's actually of immense importance to borrowers.
Okay, so if I'm sitting as a borrower out there and I'm in distress and I feel that my lender has not made a reasonable offer to me, and I'm looking at this directive and I'm saying, is this a game changer for me or not?
Yes.
Okay, and what I'm hearing is, well, the rights I had, if I'm reading this as a layperson, okay, they're saying, well, what difference is there here? Because the language seems all the same, okay? Yes. And the banks will tell you, and the central banks will tell you, and the minister will tell you that all of the borrowers are supposed to make, engage in persons' ability to pay their credit. So it's the same type of language that's in this directive.
Yes.
So what is different? Okay, and you're saying that this, is a hard law from the European Union that a reasonable effort has to be made. But does that not going to come back down to the judgment of the judges at the end of the day, in terms of what is reasonable or what is not? So what's reasonable for one may not be reasonable for the other. Like there is no explicit rights here in this directive, that says that you have to be offered X, you have to be offered Y,
Yeah, but all law tends to resolve or revolve around a judge's assessment of what's reasonable. But that is the process by which the law completes the litigation which is before it. It must make a decision on reasonableness. Now, at the moment, the point that is clear is that the courts are not engaged with except in the insolvency situation, they're not engaged with anything other than the paperwork. Let's say the paperwork in relation to the title and so forth. But the courts under the new directive will have to have, in order to be judicially protecting the rights under the EU law, they'll have to actually get down into the nitty-gritty, into the granular efforts.
Do you believe that as a result of this directive that lenders will have to consider the option of partial forgiveness?
Yes, that's what it says.
That's what it says. Yes, yeah. It makes it very, very clear. There's an option, a suite of options here, offered of a payment holiday, partial repayments, currency conversion, partial forgiveness, and debt consolidation. Yeah. So one of the big problems here in the state is we have different providers saying, well, we do these wee things over here, we do them over here, but none of them do all of it. And the point here is, in your view, does this hard law say now actually, well, a reasonable offer is not a reasonable offer if you haven't looked at at partial forgiveness. Is that your
That's
interpretation?
absolutely correct, James.
Okay, okay. Can I ask you in relation to the directive, and I'm conscious other people are coming in, so I may come back in later on, but the directive develops a secondary market, okay, for non-performing loans, and we've seen in recent times how the treatment of borrowers by vulture funds compared to mainstream lenders and the interest rate environment is very clear in relation to that. So do you have concerns that the directive will provide for further securitisation and the growth of the vulture fund market here in Ireland, or indeed not even here in Ireland, but vulture fund market across Europe, because this allows for, not even across Europe, but across the globe, because this allows now for purchasers of your debt to be anywhere in the world as long as you have a credit servicer somewhere in the European Union. So we could have somebody in Hong Kong buy in, you know, who's the next bank that's going to sell their loans? It's going to be Ulster Bank. Ulster Bank is going to sell their loans after they did the agreement in terms of the trackers. So those loans could be sold under this directive to a credit purchaser in Hong Kong. The credit servicer company could be in Poland, and all of the challenges in relation to that in terms of language barriers, time barriers, all of that. But it is about increasing the secondary market here without the consent of the borrower. Do you have any concerns in relation to that?
I don't actually.
Okay.
Surprisingly, perhaps, but because I think the bargain that's been struck in Europe is that there should be a free-flowing capital market, and at the same time that the consumers of capital, the consumers of debt, should be entitled to the directives stipulations in relation to dealing with mortgage arrears. So and that there should be, if you like, cross-country enforcement of that, so that in an ideal situation we wouldn't have a central bank which was not actually engaging with the public, which closes its doors on public inquiries. We would have a central bank which either sets up a private arrangement, which would be a code which will be enforceable, and then that the matter will then be properly litigated.
But that's fine. But the directive takes this into a whole different new space, where it's not going to be our central bank who's regulating these credit service providers. So no point talking to the central bank anymore, because what this credit directive allows is for the central bank in Poland or in Italy or in Malta or wherever to actually regulate. And the big concern that has been expressed by some is that there are different rules in relation to different legal and consumer protection frameworks in different European countries, and that this directive could allow for a race to the bottom. Why do we have so many companies regulated in Malta and passported into Ireland and other EU jurisdictions? Are we now going to have? Sorry,
it's not the weather.
It's not the weather. No. So are we going to now have a situation where your debt is held by, you know, a credit service provider in a jurisdiction that has weaker consumer protection rights than what we would have here, despite all the challenges here, or a different legal framework, and they are then allowed to passport into. So they're not regulated by the central bank.
They're only regulated in the sense that they must comply with the EU directive in that regard.
Exactly, and how you transpose the EU directive, as we discussed earlier on, is absolutely crucial. So you could you not have under this directive a race to the bottom?
I'm certainly concerned that the central bank here, I'll flip the coin here, that the central bank here will be inundated with applications from credit servicers in Portugal, Belgium and so on to set up shop here, and then leave a telephone number in the central bank headquarters and say, we'll talk to you. That's our number if you want to contact us. That the central bank will say, we really don't have the manpower or the skills to equip ourselves to regulate the Portuguese credit service market. So, and I think the whole thing will be there will be a regulatory arbitrage, and people will go and looking for the lightest touch regulation. And I'm afraid they're going to come to Ireland.
Okay. I'll leave it with I'll leave it at that, and maybe come in later on if that's okay, Chair.